Welcome aboard Rocket Ship, the platform with the most relevant content for competitive examinations. This is Rocket Ship IAS Lab, and continuing with our series on answer writing for general studies papers of civil service main examination, we would take up a question that you might encounter in GS paper 1. Here goes the question. The entire promise of fundamental rights of citizens is built on the right to constitutional remedies. The entire promise of fundamental rights of citizens is built on the right to constitutional remedies. Elucidate. Provisions in Constitution that establish the inviolable nature of the right to constitutional remedies. So the first part of the question, it talks about how the right to constitutional remedies is so important, it is so you could say prominent, that we can say that the entire architecture of fundamental rights is based on this very right, the right to constitutional remedies. And in the second part of the question, you have to talk about the, as general, as usual, the provisions in the constitution that establish the inviolable nature of the right to constitutional remedies. That is, this right cannot be violated in the first place. And what we are doing here, we are starting with a well-known legal maxim, which is ubi jus, ibi remedium. As you can well understand it, you might have made out its meaning, but anyway, it's a Latin proverb which translates to where there is a right, there is a remedy. And this proverb, that is ubi jus ibi remedium, it demonstrates the centrality of the constitutional remedies to fundamental rights. Again, it's you can easily make this connection that wherever there is a right, there must be redressal or remedies available in the case of their violation. And this right is of such paramount importance that Dr. B.R. Ambedkar, the foremost among the founding fathers of the Constitution, he calls this right, that the right to constitutional remedies, the very heart and soul of the Constitution. You would naturally like to ask what made Dr. B.R. Ambedkar make this observation that this was the most fundamental right of all the fundamental rights, the very heart and soul, not of the section on fundamental rights, but the entire Constitution itself. We would see in the following section, actually, in the following lines. It looks a truth self-evident that other rights would become devoid of meaning. You can understand it very well now, that if the Constitution were to give you just the rights without the adequate redressal in case they were violated, what was the meaning, what would have been the meaning of these rights in the first place? So this right ensures that there is some meaning, that the fundamental rights are meaningful in the first place. And the Constitution of India makes arrangements for enforcing constitutional remedies through very important articles, which are Article 32 and Article 226, Article 226 and Article 32. The Article 32 deals with the writ jurisdiction of Supreme Court, and it covers fundamental rights. Article 226 concerns the writ jurisdiction of the High Courts, and it covers statutory rights as well as fundamental rights. Please appreciate this basic difference here, that Article 226 covers statutory rights as well as fundamental rights, while Article 32, that is the writ jurisdiction of Supreme Court, it covers just fundamental rights. Now, remedies are a nod to the original position of a just, law-abiding society. We are introducing a very important concept, a very philosophical concept here, that is the position, that is the idea of original position. What original position means, that in the ideal case, again we would repeat it, the very you could say meaning of original position is that in the ideal case we would want a society that is based on just principles, as well as where there was some form of law abidance, rather than this society being run by the whim of the you could say the powerful or the ruling. The society must be run, the society would have been run through some well established laws, and the right to constitutional remedies, it is a nod to that original position of a just and law abiding society. Now remedies serve following functions. What are the functions that remedies serve? The constitutional remedies, they are first restorative in nature, that is they help undo the injustice. In case there has been some injustice done to an individual, the constitutional remedies, the right to constitutional remedies would lead to restoration of his freedoms. One example, they help stop injustice, the example being that of the writ of prohibition. As most of you would probably know, what the writ of prohibition does, it leads to, generally the writ of prohibition is issued by a higher court to a lower court, generally in a lower court or some other authorities, and it leads to stopping all the proceedings that has been going in the lower court or in other authority, in case there is some fear that injustice would be done to an individual. So what happens, the constitutional remedies, they stop injustice in the track that even before they are done. As we were just discussing, they give expression to rights. Without the right to constitutional remedies, the entire promise of fundamental rights would become devoid of meaning. It would ring hollow. They ensure primacy of constitutional rights over, you could say, legislation, that is lawmaking. Any law cannot violate the constitutional rights of citizens. This is the principle that the right to constitutional remedies establishes. They promise protection ab initio, that even before a violation has been done, else rights won't be exercised. To give you one example, which we would again discuss in detail, suppose take someone's freedom of expression. There is some cost attached to voicing your criticism of the powerful, for an example, and if the constitutional remedies, if the constitutional protection was not available, most of the people would fear for their well-being, and they won't voice their criticism of the powerful or the ruling. In that case, the very the very freedom of expression would become meaningless. That is what they do. They promise protection even before a right has been violated. They are explicit in saying that your rights are protected. Taking up these points in detail, the writs issued under Article 32 are restorative in the sense that they can restore the freedoms of individuals if they have been violated. The example we are giving here is that of the writ of habeas corpus, which you probably know. It can free an individual, it can free someone from illegal confinement. It is generally issued when someone has been illegally confined, and this would lead to his or her freedom. And you probably know that this is a very important writ, and it generally leads to filing of a criminal case. Anyway, the writs can also stop injustice before it is committed. This is best reflected in the writ of prohibition. As we were just talking about, what happens when the writ of prohibition is issued, it generally stops all the proceedings in a lower court or any authority if there is a fear that injustice would be done to an individual. It is intuitive that constitutional remedies give expression to rights. In the absence of redress, the promise of rights would ring hollow. Moreover, this is another important article that we are introducing here, that Article 32 along with Article 13, which accords primacy to rights over legislation and executive action, ensures that there are effective checks on brute majority and executive action. We would again like explain what we are trying to say here. You are probably aware that Article 13 talks about the primacy of the fundamental rights over the legislative law. That is a law that has been passed by the parliament or any other legislative body. It says that they cannot violate the fundamental rights. If they are violative of fundamental rights, those laws, the legislative law is likely to be set aside. So what it does, it essentially establishes the predominance. It establishes the fact that the fundamental rights are more important actually than the you could say the decision or the whim of the legislature or the ruling government. The constitutional remedies promise constitutional protection ab initio, so that constitutional protection ab initio, that even before the fact, so that the rights are exercised without fear. The example that we have already discussed and we will discuss again. In their absence, that is, in the absence of the right to constitutional remedies, the absence of the remedies, there would be a chilling effect. Please highlight it, this concept of chilling effect on rights like freedom of expression. What chilling effect means, that when there is you could say there is fear that there would be consequence, for an example, for voicing your criticism of the powerful or the ruling, most of the time it would lead to the chilling of the dissent. It would lead to chilling of the freedom of expression itself. People would be fearful. They would fear that, fear before, you could say, for an example, say that before criticizing the powerful or the government. And democratic dissent, that is very, very important for the functioning of a democracy, that you are disagreeing with the government, it won't even be exercised in the first place. Now, for something of so transcendental significance, the Constitution affirms the inviolability of Article 32 and constitutional remedies. What are the provisions it makes? We would discuss some of the important case laws here too, some of the important judicial pronouncements as ruled in the Skill Lotto versus Union of India. It is a recent case. It was probably pronounced in 2021-22. It says that Article 32 is an inalienable feature of the basic structure of the Constitution. And by this you can make out that this article, that the constitutional remedies cannot be taken away even by amendments. Now, in the landmark MC Mehta versus Union of India, the remedies have been held to be not restrictive, and that is, the appropriate redress can be arranged even through compensation, that a person whose rights have been violated can be suitably compensated in any form. So it's not only restorative, but it's compensatory too, as was held in MC Mehta versus Union of India. Now, even during an emergency under Article 352, you are probably aware that Article 352 deals with national emergency. The constitutional remedies exist, especially in relation to Articles 20 and 21, that is, procedural justice and personal liberty and sanctity of life. That even during an emergency, if for an example a government were to devoid you of your personal freedom, for an example it were to illegally confine you, or it were to lead to someone's bodily harm, it had to do someone bodily harm, the person, the individual would have a right to move to the court for the enforcement of his rights under Article 21, that is right to life and personal liberty, and also the procedural justice that comes under Article 20. The Article 20 actually it deals with 3 sub rights. It mentions 3 rights under it, and even when there is a proclamation of emergency, you can move a court for the enforcement of your rights under the protection under Article 20. Now, the to sum up, the conclusion we are making here, that remedies give concrete expression to rights and create a fearless environment, an environment which is without fear, where they can be, that is, the rights can be exercised. So we can say through these two things that they are, first, they provide meaning to fundamental rights, and second, they create an environment where the fundamental rights can be exercised in the first place. We can say that the right to constitutional remedies, it provides the bedrock on which the entire building, entire edifice of fundamental rights is built. That is how we sum up our answer. We would reassemble for the next lecture in a few days. As usual, we wish you all the best. Thank you.